Well, great. So we're going to call to order the meeting, although with no quorum, the meeting of the disqualification subgroup of the background study task force. Knowing that we don't have quorum, we are going to record and we are going to have a discussion today on the child foster care rules. And as we add people, we may achieve quorum, and we'll identify it at that time. If Mr. Vogel can keep me informed, I'd appreciate it. And I think otherwise we're going to have maybe even, we'll start even in this case or something even informally about the child foster care rules as they relate to the work they were doing. And as you need Mr. Vogel to provide the spreadsheet, we can do that, and appreciate you taking the lead on this, but I want to certainly give it its time. So Ms. Kaser, please.
Thank you, Mr. Chair. So in general, and I'm not going to be as articulate, and maybe if Mr. Page was able to join us, he could articulate a little bit more. But basically, to give some context, the biggest changes with the foster care statute changes that went into effect this July was really they removed the schema that 10, the 15, the 10, and the 7, and really went from a permanent and a 5-year. And they really eliminated or reduced the amount of things that would be considered disqualifications on a criminal background to really align with Adam Walsh. So really trying to streamline, keep things consistent. Now, I don't think everything is as Adam Walsh, or I think that might be something that we could talk further about, because I think there are still some criminal charges that are considered disqualification. So it didn't maybe go far enough. It didn't completely, but they tried to streamline it or align it. But probably through compromise and lots of other things, that they have what they have. So that's as much probably background as I can give, and then certainly Will could put up the spreadsheet that shows kind of, I think, some of the different crimes that previously had been on the list that I'm not sure if that means that they were removed or changed in some way.
Ms. Kaser, I suppose I should really clarify what I was doing with this spreadsheet.
Yeah.
So these are the crimes listed by the new statutory language that went into effect in July. And what I did here in color coding was I went back and essentially I compared this list to the list that already existed in statute, and compared where these particular crimes show up elsewhere in statute for other forms of background study-based licensure. So, for example, first-degree murder shows up in this new language that shows up also on the permanency list that already existed. Whereas criminal vehicular homicide shows up in this new language as a permanent DQ for child foster purposes, but was in the 15-year disqualification list elsewhere in statute. So this isn't doing anything to the previously existing statutory language. This is just the new list that's gone into effect for this area in particular, and sort of comparing what crimes are show up where, if that makes sense.
Yeah, so basically you're showing us the two buckets, the permanent and the 5-year, and color coding was where they are in other parts of statute for other backgrounds. Thank you, that's helpful.
Can I ask a clarifying question? So for example, the false imprisonment, it has a green color code to it. Mm-hmm. Does that mean under the current child foster care statute, it is a permanent disqualification, but in other areas, it's a 15-year disqualification?
If I'm reading the statute correctly, that's correct, Mr. Chair.
So there were some areas where the disqualification period went from 15 years to permanent.
Yeah, that would be all these greens in this column, for example, and even a few that appear to just be in the gross misdemeanor / misdemeanor lists. Conversely, though, Mr. Chair, basically all of the greens and blues in this 5-year column are, in a sense, downgrades from the previous statutory scheme. So, for example, the controlled substance crimes here are 15-year disqualifications under the previous statutory language, but this new language is placing them in this 5-year disqualification category.
So it's fair to say, I think, Ms. Kaser too, that your understanding is that some disqualification periods were made longer and permanent, while some were shortened.
Yes.
Okay, I didn't know that. I appreciate that. Thanks so much.
Yep. And some are, I mean, able still to go through reconsideration and some are not. There's some that are considered what we call bars. So, and that's part of like Adam Walsh. So, you know, murder in the first degree is a bar. And so even it's a permanent disqualification, but it's also not something that can be reconsidered. And there are some things that can still be reconsidered, even if it's a permanent disqualification, if that makes any sense. And that's something that we have to still be sorting through. And a comment I would make kind of going forward is it's rather confusing what we have to kind of work through. And then the ones that are not color coded, those ones were eliminated. Would that be fair to say, Will, from the foster care?
The ones that were not that I didn't color code, I didn't see explicitly mentioned in the previous statutory language, although I would suspect these are a lot of substance related things. So I would suspect I was just misinterpreting that quickly going through. I would suspect these count as drug crimes for the 15-year DQ language. These, however, so the blue color coded ones are the ones that show up in the permanency list, the 245C15 subdivision 1. And they can all be found replicated in this new list under permanent or 5-year DQs, with the exception of sexual extortion and incest, which I couldn't find in this language. Let's note this is me just going over this statute, though. So, if a second pair of eyes sees something I missed, please let me know.
And I probably did come prepared for it, but I could pull up and send to the group, certainly. So the Department of Human Services has posted on their website for licensors as a resource, kind of the disqualifications list that we can use as a guide, kind of on a quick level glance to know when we have a potential foster parent, either relative or non-relative coming in, would there be disqualifications based on the statute? And so we utilize that resource, but that's also gotten more complicated.
Is the statute as it's written only for relative caregivers, or is this for everybody who wants to be a foster parent?
It's really focused on relatives, but it applies to, I think, all family foster care, child foster care.
And Mr. Chair, we have been joined with Mr. Page, so we do now have quorum.
Wonderful. Great. Now that we have quorum, we are fully on the record. Maybe we'll just keep going for now, Mr. Vogel, but we'll come back and we'll adopt meeting minutes from last time. Mr. Page, just want to thank you for joining us. We have a bit of a small group today, but we're having discussions of the child foster care rules and the newer statute, and Ms. Kaser has been leading us on that, and Mr. Vogel's provided this to us, which is a very kind of helpful list of offenses that are permanent, which ones are 5 years, and where they were prior to the new statute. So that's kind of where we are.
Thank you, Mr. Chair, and apologies for my tardy attendance.
I certainly understand it, but appreciate that you're here, Mr. Page. Could we get kind of an analysis or just a discussion, certainly nothing that thorough, about what were your understandings of what led the legislature and community advocates to push for changes in the child foster care rules?
Certainly. So my understanding of how that came about was in a lot of child protection cases, we had children who had been removed from their parents and had very clearly fit and willing relatives that they could live with. In fact, some that they had spent many months or years with, but because of an old conviction, once the child was officially in court ordered out of home placement, then they had to have a license to be a foster care provider. And the licensing scheme, which is the one that we're looking at as part of this working group, didn't allow for a lot of those placements, even though they were, perfectly capable and willing caregivers for children. And so Hennepin County had proposed a pilot program to do a stripped down version of foster care licensing requirements just for relatives. The Department of Human Services said that that is not possible. They have to be universal foster care standards. And so the county attorney's office, the county attorney's association, and the Institute to Transform Child Protection at Mitchell Hamlin, which is a clinic or an institute at Mitchell Hamlin, sat down and negotiated new language with the assistance of DHS and some other partners over the course of a few years. And so that was the superhero origin story version of how those changes came about.
Ms. Kaser, as somebody that works in this area, I would be very interested in just getting your understanding of some of the challenges that you saw, specifically prior to the changes, and maybe later we can talk about since then, although we've only gotten about, 4 or 5 months. But what did you experience as a professional in the field?
Well, I think as Mr. Page noted, some of those situations have occurred in our agency. So I actually have a situation now. We've been trying for some time to have a child be adopted by some relatives actually. And because of a drug conviction that one of the individuals in the household had that is not more than 5 years old, they're permanently disqualified. And this child has been in their care now for going on 2 years, because we are trying to go through a reconsideration process and all of that, and thriving. This youth is thriving in their care. They have done some wonderful things around their sobriety. They're leaders in their community around all of that. And because of the way the statute was written, and this was prior to, again, the changes, they would not be able to adopt this youth. And we saw that as a real disservice because, we always try very hard to place youth with family and kin. And we know through research and through studies and just even anecdotally, kids do so much better when placed with their relatives and kin long term. We see less disrupted adoptions for youth because those relatives and kin commit to those children. And because maybe some choices that individuals made in the past, there's some real restrictions on their ability to then be that permanent option. So it always feels really awful for us to say, we know you'd be the best option for the kid, but because you can't get licensed and because you need X, Y, and Z to be able to finalize this adoption, we have to place them with either a different relative or a non-relative potentially. And so we've had to do those situations where we've had to remove children from a stable placement because they're not able to get licensed. And that just feels wrong for us, especially when a child or youth is doing really well in their care. So, when Mitchell Hamlin was actually going through this process years ago, we joined some conversations our county did around how could this look different and how could we advocate for changes? And one way that we saw that, which I think this law now allows, is giving more control, if you will, to those local agencies to make some of those decisions, to use our assessment skills and our understanding of the family dynamics and what's going on to really assess for ourselves whether it's a risk for that child to be placed with those individuals or not. Instead of just kind of this blanket, it's the rule, we can't do it. because people certainly have capacity to change, and we believe that. And not everyone, certainly who has that criminal background, maybe makes those changes, but some do. And so this allows for some of that assessment at a local level. But then there's complications with that too. So, which I can certainly talk about, but I've been happy with that change. Personally, I think that it's a move in the right direction. And Minnesota is the most restrictive state, I would say, in terms of how we went through licensing individuals or allowed for that. You know, and I think there's numerous stories, or there were numerous stories about that, but we're not immune. We experience that here as well in our agency.
When you were talking, Ms. Kaser, about those moments where you thought as an agency official that it was a better placement within a certain relative caregiver, but we're not allowed to based on the statute. Was that something that occurred once or twice, or was it something a little bit more common? Just trying to gauge how often that occurred.
You know, it probably could have happened more commonly, but I think because we knew individuals sometimes weren't going to be able to be licensed, we just moved forward and didn't consider them, which again is a disservice to those relatives. They certainly should have had the opportunity, but we really didn't give them the opportunity because we knew that they weren't going to pass, you know, a background study. So it could have probably happened more frequently, but because we knew the parameters we had, we probably sidestepped some of those situations.
Certainly. Mr. Page, hearing Ms. Kaser's recitation of her experiences, are those consistent with what you have heard or experienced, or are there some other pieces to that you think are important to add or identify?
Yeah, I think that's been very much our experience in Hennepin County as well. I will say even with the new changes, there are some relatives who have permanent disqualifications that would likely be very good caregivers. And so it's just a reality that no matter what hard and fast guidelines you put in place, it will not fit everyone's circumstances perfectly. And so I guess, excuse me, I would also say that and I don't know which way this cuts really in our analysis, but providing care for children and for relatives is quite different from, you know, doing some of the jobs that we're being asked to analyze and view disqualifications in the light of. You know, parents are presumed by the Constitution to be able to parent their children, and that caregiving role, I think that a lot of those caregiving functions are kind of presumed on others when they're licensed by the state. And I don't think that's necessarily true in all of the jobs that we're talking about. But on the other hand, you know, children are, you know, I would argue much more important than some of the jobs that we are considering here. And so, like I say, I think it could cut both ways.
Mr. Chair, sorry to interrupt, but some members may need to drop out pretty soon, so it might be a good idea if we want to do the minutes to do them now, actually. Oh, you're muted, Mr. Chair.
Sorry. Yeah, let's do that then. So now that we have quorum and we have a situation where, well, we had meeting minutes posted by Mr. Vogel from our last meeting, which would have been the 4th, I believe, of October. And those meeting minutes were posted on the website. So has anybody had a chance to review them who has any concerns, changes, or recommendations? Okay, seeing no hands raised and nobody saying anything, we're going to adopt those meeting minutes as posted. Thank you, Mr. Vogel. Good to see you, Mr. Irvin. Thanks for making time today. Appreciate it.
Sorry I'm late.
We all understand. What about Ms. Kaser, Mr. Page, or certainly anybody else who's had experience in this? what has it been like since the changes were implemented? What's worked and what has continued to be a struggle?
I have been in a new position and not doing child protection work since the changes went into effect. I will be going back to child protection in January, but that doesn't help this conversation at all.
I'm happy to give a little context, certainly. So there's a couple of things that kind of happened in this last legislative change. So some of it kind of blends together. So not only was this background study change happen, but there was also some stronger legislation clarifications around what efforts agencies need to make to engage and consider relatives for placement of children. So there's two complications there, but just keeping it focused on background studies. What has been probably most complex for us is the implementation of it all. It goes into effect, and I think it's just figuring out how to work with the new rules. We were under a different set of rules for such a long period of time. And now like I said, we used to have kind of a list. We kind of knew what were things that would not disqualify or would disqualify an individual. And now that feels a lot more up in the air. And so oftentimes in our unit in foster care, child protection will come to us and consult with us and say, hey, I have a potential family that might need placement, or we might have a child going into placement. It's high risk. Here's what's going on. Hey, I have a potential grandma, for example, who I think would like to be the placement option. And they'll ask, do you think they're licensable? And in the past, I think we had a little bit more confidence around yes or no, based on, we could look at social service history as well as criminal history. It just feels a little bit more ambiguous now and up in the air. And so we have a harder time saying, yeah, we think that they're licensable. Let's move forward with, a referral and all of those things. We're having to come back and kind of say, we don't know. We won't know until we start the process, and we have to go through the process of, and it can be quite a lengthy process. So where that maybe leads to complications is potentially we could be moving kids lots of times, and we don't want to do that. We're always trying to place kids, first and foremost, obviously with relatives and kin, but trying to really reduce the amount of moves children have, because those are pretty traumatic. Even if it's in the best interest and safe for them, it's still traumatic for kids to move. So potentially we have multiple moves happening, because until we get through the start of that licensing process, do the criminal background check, and knowing if they're disqualified or not, we have a child in that home. And then if they come up that they're disqualified and say it's something that we can't get reconsideration around, then we have to move them.
Can you explain how that's different? Because like if you had like a 7, 10, 15-year disqualification kind of scheme, and now you have sort of the 5-year permanent, what's different about not knowing up front? I might be missing that.
Well, and and I think it's just a lack of familiarity probably with what is considered a permanent or 5-year. I think again, we were pretty familiar with the different breakdowns before, and someone who maybe had a 15-year disqualification, we had some insight into whether that was going to get through the reconsideration process or not as well. Whereas now we don't. The other factor with that is Department of Human Services is still sending us the information that previously would have been a disqualification. So something that, let's say, was a 15-year, and it's not on the permanent and it's not on the 5-year, it's just was eliminated somehow. An example, or maybe it was on the 7-year, domestic assaults. Some of domestic assaults are not considered disqualifications any longer, but we are provided that information that they had a domestic assault. So then we're stuck in this weird place of, okay, well, how far back do we look? How far back do we go? Do we assess that? Is it something that's going to be a problem or not? And now we have to fill out these long forms as to really justify why we were going to move forward with that placement. So we have to do a risk assessment, and it's a pretty lengthy assessment that we now have to do. So again, if we are looking at multiple options to place with, how do we narrow in? How do we determine? So we're not moving kids multiple times. Based on, we don't know what's going to pass or maybe not. And if we're going to be able to license them or not in the end. So it added to just a little bit more grayness to the work, which is okay. We'll have to figure that out. That doesn't mean it was a bad thing. It's just a transition and a change of how we've been doing it. So for our county in particular, I know we are actually hiring somebody to help kind of figure that out within our team, because it's just a new way of doing the work.
It seemed that anytime you add any level of discretion, you take on significant more responsibility, and just more work.
It is.
Yeah.
And then I think that lends to the other challenge, which it's always the other side of it, is now we have 87 different ways that might be done. Because now it's been delegated back down to counties and tribes. And so there's going to be some inconsistencies, I think, across the state of how it's going to be implemented. Because where we might be more flexible and say, yep, we're going to move forward with licensing, and we're going to, yep, it's not a disqualifying crime, and we don't see that as a risk of harm to the youth, we're going to license them. A county over from us might say, well, even though it's not a disqualification, I still see it as a huge risk, and I'm not going to license them. So again, something that we'll have to work with the state and around.
And Mr. Page or Ms. Kaser, do you know what the due process rights are for an individual who is denied a foster care license on that? Do you get a fair hearing on that, or what's the?
So that is heard by administrative law judges, I believe, and you get a full hearing on that. Mm-hmm. There's additional levels of oversight, including a court process, a child protection case in which a person can bring a parent, or the department can bring a motion, and DHS is that third level of oversight.
Mm-hmm.
That makes sense. And Ms. Kaser, is there anything else? I'm going to ask you a hard question in a moment, but is there anything else that has been challenging or heartening about the changes into the child foster care statute?
Probably one thing that was a change, and I know after last week, this was touched on briefly, but just there was a change that an individual has an involuntary any termination of parental rights is a 20-year bar. And that's pretty complicating for our world, because we certainly have, I've worked cases where an individual did have a previous termination, and maybe is parenting their own biological children and wants to be considered for a relative, a niece who's coming into care. And we were able to work through some of those situations, I think, in the past, and this puts a little bit more of a hamper on that.
Any insight, Mr. Page, on, I mean, it is an interesting thing that there's the 20-year bar on the child foster care for the voluntary termination cases. Do you have any recollection of what were some of the concerns during that discussion?
Yes, Mr. Chair, there was most of us believed that.
Could you hold on 1 second, Mr. Page? I did get a notice. I don't know if everybody heard it. That recording stopped.
Sorry, Mr. Chair, I'm checking behind the scenes right now.
Mr. Page is going to say something very eloquent that we should have preserved for the record, so I want to make sure it is.
I knew we all heard it because I saw the look of horror on Mr. Vogel's face.
That's a cruel April Fool's joke to do to Mr. Vogel.
Carol, are you there? Okay, it looks like we've lost our tech support. I'm going to start recording on my end.
Thank you, Mr. Vogel. And we can maybe figure it out. Just for the record, we lost recording for a moment. We interrupted Mr. Page and asked him to stop talking immediately. And now we'd like to invite him back if he can remember what he was going to say. Thank you so much, everyone.
Thank you, Mr. Chair. The group that had been working on the legislation for a few years all agreed that termination of parental rights should be something around 5 years, given that you also had to have this home inspection and, be deemed by the local social services agency to be a suitable home and caregiver. There was a smaller group of the people working on the legislation that believed parents who have had their parental rights terminated should never be able to parent another child again, including in foster care. And the 20 years was a compromise between those two positions, one that was unsatisfactory in my mind, but as Representative Robbins knows well, there is a lot of compromising that goes on when you're passing legislation. And so that was the result of some of those negotiations. Just speaking from experience, there are a lot of parents, particularly in the Native American community, who have struggled with addiction issues, lose custody of their children or have their parental rights terminated and then recover and are actually really pillars of the community. And we thought that some of those should be eligible to provide foster care for their relatives if they have made it through that process. But ultimately, those arguments were not persuasive.
I appreciate so much, Mr. Page, just the context and understanding it a little bit more. All right, Ms. Keiser, I have a really hard question. Did the changes make the statute better, in your opinion?
In my opinion, yes. I think it better aligns with Adam Walsh and makes it a little bit clearer and a little bit simpler, even though we're struggling to figure it out right now. I think in the end, it's going to be clearer. And I think probably some recommendations, and I wish Ms. Sherlock was here because I think she'll have some opinions about maybe there's some ways we could go further because there's probably still some crimes that are listed that are still maybe a little above and beyond what Adam Walsh would say. Yes.
I get what you're saying about clarity and kind of ease of understanding. If we're looking at it just though under the lens of protecting children, do you think the changes have had any kind of negative impact on children's safety?
Not that I can see so far, no.
And I should have qualified it as such, but I know I'm just speaking from your experience as somebody in the field. Okay.
Yeah, not that I've seen so far. I mean, granted, it's only been implemented since July, so it's probably hard to say long term because we don't have the crystal ball. But so far, I don't see it has led to any more risk of harm for children.
Thank you. So one of the questions I have, and it's a big question, and so we have this section that's sort of carved out for the child foster care laws, and what we've been talking about for many months is the other part of the background study law. We have to kind of figure out moving forward how those two meet and mesh, and I guess I don't have any idea on it beyond the fact that we have to address that, because if we create a statute that's changed, then we really have to kind of synthesize the child foster care rules to the new recommendations. Do we leave it separate? Do we synthesize it? What are your guys' thoughts on the best way to kind of do it, if anything? And I know Mr. Page talked about kind of leaving it alone because we just were there on it. but it is a question.
Mr. Chair, we have just been joined by Ms. Sherlock as well.
Oh, Miss Sherlock, we're glad you're here.
Hi, sorry I'm late.
We missed you. So, Ms. Sherlock, we've had a lot of fun today. But one of the things we're talking about moving forward is how do we deal with the changes we're recommending to the Background Study Act and synthesize it or not synthesize it with the changes that were made to the child foster care laws, in terms of like, how do we deal with this?
Did you guys resolve that before I joined?
No, you have been selected as the person to resolve it. No, I don't know what we do.
Well, I mean, I think there's something to the fact that they're not the same now. These background studies were all the same, and as of July 1st, 2022, they're not anymore. So I don't think we necessarily have to mirror them, but I do think there's some nice changes for foster care that could really go across for other purposes of background studies also. Max, did you share by chance already before I got here? You had alluded to the fact that there was quite a bit of discussion around the 20 years and the involuntary versus voluntary, or I should say voluntary and involuntary. Can you share that with me? Because I'm really curious.
Well, we had just discussed that, Ms. Sherlock, and
Sorry.
no, that's okay. Essentially, there was a group of people that believed that termination of parental rights should be a 5-year disqualification. There were others that believed it should be a permanent disqualification. If you lose your rights to a child, you should never be able to parent again. And the 20 years was a compromise to get that included. One additional observation, I don't think voluntary versus involuntary termination of parental rights gives us a lot of information about what harms actually happen to the children or what risks are present. You can have a parent who, engages in horrific, really bad abuse and or sexual abuse of their child and does a voluntary termination of parental rights because they know they have very little shot at retaining those. But they're not necessarily a safer caregiver than someone who is addicted to chemicals and just doesn't show up to a hearing and their parental rights are terminated by default. 5 years down the road, I think the risk assessment for those two individuals would be quite different. One concern that I would have, Mr. Chair, on the issue of kind of bringing current non-foster care statute into the foster care statute framework, just picking it up and putting it in, is that for child foster care, there are social workers who are on the ground and able to do these analyses and work with families to try to get them to be licensed. And I don't know that exists for other kinds of jobs when you're applying I'm not fully familiar with how you apply to become licensed for some of these positions, but absent some of that assistance, guidance, and help, I think it needs to remain a separate statutory framework, just because that is anticipated with the child foster care framework.
Ms. Sherlock, Ms. Kaser, what are your thoughts on that as just a general premise, kind of keeping them separate and then figuring out, because there could be a point, where we suggest and recommend changes to the other statute that some people find, hey, that's a good idea. It should be part of the foster care, but just keeping it separate, is that something that still makes sense?
Tiffany, do you want to go first?
Please. You, Ms. Case,
Thanks, Ms. Sherlock.
steering contest. She had the first 45 minutes.
I did. I could see benefits of leaving it alone because we just don't know again yet the full impact of it. And so it's hard to maybe make recommendations without that. And two, I agree with Mr. Page's point that when we're doing licensing, you have multiple individual social workers in there assessing and determining, whereas other fields might not have that. It's going to be more of a quick glance and not an in-depth analysis risk assessment that's being done. So I could see that. I could also see, in the future, there could be also recommendations to clarify or align, these two laws in the future. That could be something that we could recommend, is to say, continue to keep an eye to this so there's consistency, and where there's opportunities for alignment that could be done in the future with the foster care law. But I could see just leaving it alone.
Okay, thank you. Ms. Sherlock?
Part of me feels the same way. This change just happened in foster care licensing, something that many of us have been trying to get changed for a very long time. And we don't know yet if this was a huge mistake, that all these changes are going to result in kids being harmed in foster homes or not. I suspect it won't. I suspect we won't find that, but time will tell. And so selfishly, I, in some ways, am concerned if we tie these back together and our recommendations aren't adopted, what's going to happen with the progress we've made in foster care licensing. That's one concern. And I do think if we find down the road that it hasn't caused egregious harm, these changes to kids, that we will have more maybe reception to making some further changes as we go as well. But like Ms. Kaser said, to tie them back together if there's an opportunity, because I definitely think some of the changes would benefit employers looking to hire staff in these positions as well, that have had some background, some concerning history, I should say.
And from, I think for Mr. Page, Ms. Kaser, Ms. Sherlock, you guys are, in the proverbial trenches. As somebody that's not in them on the child foster care stuff very often, it seems intelligent to me to keep them separate, to focus the work on the other part of 245C that's about kind of everything else that hasn't been changed, and then revisiting the work of that has already been done, and having some studies in, hey, is this working? But I don't want that to be a disservice to the members of the group who think otherwise. So it doesn't sound like there's disagreement on that. Does anybody have a different opinion on that? That makes sense to me. If we add that as a bullet, and I certainly would feel willing to kind of take a shot at it, to not say like our bullet is that for child foster care, leave it separate. There might be need to revisit it in the future if changes are made to the rest of 245C, and after viewing how the changes sort of play out since they were just implemented in the summer of 2022. Does the group see that as a good idea moving forward, or are there concerns with that approach?
Mr. Chair, I always like the idea of us evaluating changes that have been made to see if they were good changes or not. So a recommendation, I don't know that DHS has built in anything to evaluate the changes that just took place, but I'd love to see some effort in that regard.
It's a good point. We had some discussions with data on some of the concerns we had throughout the process, that sometimes it's hard to get data from DHS, and that it's not DHS's fault per se, but just that there aren't these sort of pieces put in place for data gathering. And we could include that. Ms. Sherlock can share it. Of course, we'll always share it. But that would be an example of something we'd like to see moving forward, that as we make changes, that there are data points that are collected to ensure the safety of kids served in child foster care programs.
Right.
Yeah, that makes sense to me.
In licensing, I don't know that we pulled this out in the data, and I don't know if we could, but this is just anecdotal. I've got to believe that most of the variance requests, set aside requests for foster care licensing, the counties support that. for relatives. And we really only do that for relatives, not for, well, at least we don't for non-relatives. And unless it's a permanent DQ, permanent bar, we support most of the time, the vast majority of the time we support them for relatives. And so to me, that just seems like we're dragging the process out. We're adding a lot of hoops for somebody to jump through, this person, this relative to jump through, who now unpreparedly is now caring for kids in their home that didn't expect it. And now they have to jump through all of our process, our training, our home study, all that process, and this variance request to end with, yes, they're going to be licensed. It's just going to take us 1.5 years to do it instead of, 4 months. So it seems like I would love to see some data around how many do they deny out of licensing versus employment? And if so, is that still, who decides that at DHS? Is that one person at DHS, or how do they go through that?
We might, I don't remember us seeking that data at any point. And it might be a little late to try to pursue that.
Yeah.
It might be helpful, I think, at some point for us to develop the list of being specific about what data would we like if we had the magic wand on data moving forward, what would we find helpful? So maybe Ms. Sherlock, Ms. Kaser, and Mr. Page, if you're willing to kind of start thinking about that a little bit, and maybe even we could set up an attendance at one of the data subcommittees just to kind of list, just so, I think it's helpful to everybody if we're specific about what we're talking about, as opposed to, hey, you need to collect data. What data?
Yeah, I didn't mean that we would ask again this. I think the ship has sailed for us asking for data, but also could one of our recommendations in general be that they create a data dashboard? They have they've created other data dashboards. They've got one for child welfare data dashboard. Could we recommend that they come up with something out of licensing for these background studies? That would be at a glance that anybody could go and look.
The dashboard has been discussed and will be proposed as a recommendation to the larger group at some point to vote on whether we make that full recommendation. But 100%, I think it's been detailed. I think we still want to make sure we're being fair to the department about, hey, this is exactly what we're talking about, as opposed to we want data.
Yes. Yep.
And I'd be the first to. I've been the we want data guy before, so I agree 100%.
I think we could work on a list of specific metrics we'd want to see.
I think so, and I think it's helpful. The more information we can give, even its examples, will be beneficial and will save people time in the future. Okay, so moving forward, if I'm just going to recite it one last time, that we're not separate, we're not reconnecting child foster care license with the rest of the department or the rest of the Background Study Act. We're keeping it separate. We're creating a bullet explaining why we're doing that. And for now, we're kind of leaving alone with this data request that we get more information moving forward to track the changes to the child foster care rules. And Ms. Sherlock, Ms. Kaser, and others will all kind of put together a list of examples and some requests. Anything else that I'm missing today, people? I think we actually got good resolution on this, and I think we'll be back in a week working back now on the disqualification list of crimes and conduct. Any other questions about child foster care that we did not discuss that you think is imperative today? Okay, seeing no hands raised or any concerns being uttered, we're gonna adjourn today, and right on time. I just want to thank everybody as always. Appreciate you coming in this extra time because I think this was really helpful. We've been missing this piece, so this is really helpful. Thanks, everybody.
Tiffany,
yeah, thanks to everyone who spoke. I got a lot out of it today. Thank you.
Thank you, Mr. Chair.
Oh, Tiffany, can I IM you?
Yes,
Okay, thank you.
you may.
Bye.
So we're not going to be going through the disqualification list, or is that going to be later? Sorry.
We're not going to do it today.
Okay.
We're going to do it in a week.
Okay. Got it. Thank
Okay.
you.
Thank you. Bye,
All
everybody.
right, I will try to call
Okay.
you into a Teams meeting.
Sure.